Mr. Chairman,
Yeah,
because I'm actually a co-sponsor on this, I'd be happy to present 148 if you'd like.
really, we'd be happy to have you do it.
Okay.
Mr. Chairman, you are live.
Thank you. Okay, we'll go ahead and call the meeting to order. Representative Western, it's the second one up though. Yeah. You're good to go. Appreciate your enthusiasm. Okay, we'll call the meeting to order. Carol, if you can take the roll for us.
Representative Bear,
Here.
Representative Burkhart,
Here.
Vice Chair Duncan,
She's excused.
Representative Air,
Here.
Representative Gray,
Here.
Representative Heiner,
Here.
Representative Sherwood,
Here.
Representative Western,
Here.
Chairman Greer.
Here.
8 here, 1 excused.
Okay, thank you. So folks, we're knock out a committee bill to begin with, Senate File 40, then Senate File 148, and then on to Senate File 116. And then if we have time, we'll take up Senator Cooper and Representative Bear's Senate Joint Resolution 3. We've got committee members presenting bills all over the place. So make sure and leave your proxies committee if you can. With that, we'll go ahead and get started. And Commissioner Forkner, would you and Mr. Mulberry come forward and walk us through probably just a reminder of what we did during the interim on this. Thank you.
Mr. Chairman, committee members, Albert Forkner, Banking Commissioner. Good to be back again in person. So feeling a little more normal, other than a little bit of extra plexiglass. So what we have here, right? This was a bill that we talked about over the interim, and what we'll do is kind of just hit a few high points, if that's right, Mr. Chairman. And Mr. Mulberry, who's our deputy commissioner over the non-bank area, which includes money transmission, he'll kind of do some of the finer points just to clarify some of the technical issues. But
Commissioner Fortner, can I interrupt for just a second? I'm going to assume this is going to pass being a joint bill. Is there a volunteer to work it so you can take notes and along with it? Okay, Representative Western's just eager today, so we'll let him do that. Okay. All right. Thank you, Commissioner.
Well, this, if the members might remember last session, we had some money transmission discussions and what Wyoming was going to do in the area. And we had kind of in the middle of the process thought of a few other things that we wanted to do since we were opening up the act. Kind of got halfway through and realized some of them weren't germane to that bill. And so decided to come back over the interim. And there's only one, I would say, policy shift, but it gets in line with everything else that we do within the Division of Banking. It's regarding how we assess fees. And in fact, the other bill that we talked about, I think last Friday, kind of addresses some of this as well. But there's the evolution in money transmission space has transformed how they operate significantly. You think back in the day when you would go to, say, a Western Union branch and say, I would like to wire some money somewhere else, whether inside or outside the U.S., hand them cash or check, and they would transfer it that way. Now it's electronic. Well, the fee structure is set up on that old model. And so if you think about a gas station, grocery stores, things like that, that have the little booth or kiosk in the back of the room or in the front of the store and where you can go do that. Well, those are authorized delegates. And so the structure is based on that. However, the largest online money transmitters are paying a lower fee, but they're doing a larger amount of money transmission and things of that space. So that's the policy shift. So what we're saying is we want to still maintain the authorization in statute, but like every other fee that the Division of Banking assesses, it's set by rule. And then you go through that process and you work through the stakeholders with LSO, the governor's office, and management council. And we want to make it a more equitable and tiered fee structure is what we propose, similar to other states. So again, so think of a PayPal or a Google Pay or something like that. They do a significant amount of volume, but it's all online. So that Mr. Chairman, is Yeah, and so then there's some additional items. So I'll turn it over to Mr. Mulberry if that's okay with you, Mr. Chairman.
Any questions for the commissioner? Okay, Mr. Mulroy, go ahead.
Thank you, Mr. Chairman. I'll just walk you quickly through the remaining changes that we're making. As Commissioner Forkner said, these are mostly just technical changes, things that have caused us regulatory difficulty, and we just need of clarification. But there's not really any policy changes. So in the bill on page 2, line 6, we're making just a change instead of it saying in the business of transmitting money, we're changing that to the business of money transmission. You can see on line 8, the actual definition in the act says money transmission. So we're just making that clear there. On line 9, we're deleting stored value in that section and several other sections within the act. Because it's caused some confusion where it said payment instruments, stored value. We have to have discussions all the time about are stored value products actually payment instruments? And yes, they are. But it gives that appearance that maybe they are two separate things. And so we're just making a clarification there. By deleting the specific references to stored value. And then what we're doing in the next section in the actual definition of payment instrument, we're going to include a section that says stored value shall be deemed equivalent to prepaid access. That's another thing that we're doing for clarification purposes. In the industry, stored value and prepaid access are terms that are used kind of interchangeably. And so in the federal regulations under FinCEN, they have a definition of prepaid access, which we utilize in our regulatory efforts. And so what we're doing here is within the definition of payment instrument, we're citing that payment instrument includes prepaid access as defined under the federal regulation that we also follow. And then we're saying that stored value is equivalent to prepaid access. So whether you use the term stored value or prepaid access, it means the same thing. So we're just making that clarification. On the next page, again, you'll see that we're taking out another section of removing the stored value. Beginning on line 17 on page 3, we're just making some changes to the language in our surety bond requirement to match actually the practice of what we do with our surety bonds. There's been some confusion about what that language requires, and so we're trying to just clarify that. Initially, it said that an applicant had to provide a bond at the time of application, but if their application is going to be denied, there's no need for them to have a bond. And so we're changing it so that they can wait to provide the bond until they're notified that their application has been approved. Then we will pen the final approval, waiting for them to get the bond. But it just eliminates that need for them to get a bond if they don't need it, if their application is ultimately going to be denied. There was also some changes or just some clarification about the maximum amount of the bond. So we're just clarifying that the maximum amount of the bond is $500,000 for our money transmitter licensees. Going to page 5, and actually page 5 and page 6 are all just technical changes. A number of years ago, there were some changes made in this act. At the same time, we were also making changes to everybody's favorite act, the Uniform Consumer Credit Code. While that was happening, in the Uniform Consumer Credit Code, it refers to Albert or the banking commissioner as the administrator of the Uniform Consumer Credit Code, whereas in all of our other acts we refer to a commissioner. And so somehow it got picked up as an administrator in this act, but they all should just say commissioner because that's the definition. And so again, it's not making any change, it's just a technical clarification. Then on page 7, the renewal of the license, that's what Commissioner Forkner was just talking about, changing the way that we're doing our annual assessment of our annual renewal fees. And then the last section in under 115 on line 18, because we're making a change to the assessment of our fees, we felt that we could also make the change to our examination fee assessment. Right now, we assess the direct and indirect cost of conducting an examination, but because we're going to be making a structural change in our annual assessments, we're going to change that our examination costs, so that we're just charging the hard costs of the examination, airfare, hotels, meals, those kind of things, but we're eliminating the indirect fees for the examinations. And then the final thing under section 2 is just a few sections that we're repealing, 4022, 102. The first section is deleting the definition of electronic instrument. That is no longer relevant or necessary. We do state that payment instruments include electronic records. That definition of electronic instrument applies to a tangible object, like a card that has a magnetic stripe on the back. And so this industry has continued to evolve. A lot of electronic transactions these days are done just without a tangible object. And so we're just removing that definition because it's no longer necessary. And then the final repeal is the definition of stored value. Like I already said, what we're doing there is just make some clarification changes because we're citing to the definition of prepaid access under FinCEN, and then we say that stored value is the same as prepaid access. We no longer need that specific definition of stored value. So, Mr. Chairman, those are the changes, and I'd be happy to answer any questions.
Okay, I'll just, one quick comment, maybe for the committee, everybody, is on page 7 regarding the fee setting. You'll recall House Bill 69, which just did pass Senate Minerals Friday, has that whole process for setting the fees. And I'll just double check. We may have to do something with a reviser's bill, which usually comes in the end, to make sure everything jives up and we've got our statutes good. So that's how we'll deal with that. Okay, and then Representative Western, you got what the repealers were, because typically you get asked that question on the floor. Okay, all right, committee, any questions for Commissioner Fortner or Mr. Mulberry? Yeah, go ahead, Representative Gray.
Thank you, Mr. Chairman. Commissioner Fortner, Mr. Fulberry. I wasn't here in the interim. I was on a different committee, but this whole fee setting part of it, which appears to be the meat of the bill. I mean, I'm not worried about the line 18 change. I think that's fine, taking out indirect costs, but I'm just not understanding the thrust of line 7 through 10. I mean, I've never been a fan of conferring that fee making authority to the agency. So can you elaborate a little bit on what exactly the issue is? Because I didn't understand it when you were, I didn't quite get the thrust of what the change in the industry is that requires this change.
Yeah, Mr. Chairman, Representative, that's a good question. And so the way our fees are structured, and I'll let Mr. Mulberry step into if I bumble it up. But so again, if you think about how money transmission began in this country, and I think the most familiar company is like a Western Union or something. And then you also have prepaid cards. So if you go into a grocery store and the big kiosk at the front, it's got every prepaid card or gift card you can think of. Those are actually fall underneath this jurisdiction as well. So the fee was based upon a set amount plus a number of authorized delegates. And so an authorized delegate would be, again, if you walk into a big box store and there's a little booth or something that someone's manning, or it's the kiosks that have the displays of the prepaid cards, those are authorized delegates. And there's a fee based on the number of authorized delegates as well. So the more of those physical presence that you have, the higher the fee would be. Is that, if you're following? Well, think about, again, PayPal, and Venmo is owned by PayPal. So that's now people are transmitting money that way, or it's just done electronically. You can go online and just go to some of these same companies and submit and wire funds, again, across the country or outside the US. That is where the bulk of the transmission is occurring nowadays. This is electronically. However, and so these companies that are transmitting, 10, 20, 100 fold of what some of these other places that have storefronts are doing, are paying a lower fee. They have a higher risk and a higher supervisory cost, but yet they're paying a lower amount. So the evolution, and so the fee structure has not kept up with that. So instead of putting through, and we could go through and put a table in statute, but like I said, every other fee that the Division of Banking charges is authorized in statute, set by rule. So this would be the same thing. The statutory authorization is there, and then we'll go through the rulemaking process and set up and we have an idea, a rough idea. We haven't put, specific, tiers in place, but we kind of are gauging based on volume because we want to have the amounts. We don't need to raise the fee any. In fact, we'll probably lower some of the fees for some of the smaller transmitting companies because again, they aren't doing the volume. So this is what that structure is. It recognizes that the fee of based on volume as opposed to based on your number of authorized delegates, actual storefronts. So if there's any other questions we'll need to follow up on, let me know.
Any further questions? Yeah. Go ahead, Representative.
Commissioner Forkner, so did you guys sketch out if you did it in statute as a table, what that would look like? Or did we just go through this approach in the interim of just deleting it and setting it in rule?
Mr. Chairman, Representative, well, we haven't presented it because we don't know exact numbers yet, because we'll look at the year-end 2020 numbers. So we haven't presented that to the committee, but we have been working on that, trying to get a structure, because assuming the bill were to pass, then we will have to begin that rulemaking process fairly quickly. And we wanted to have at least a foundation to look at. Well, like I said, we haven't figured out exactly how many tiers will be appropriate just yet. And so we've thought about it, but not presented it to the committee.
Any follow-up? Okay. Any further questions, committee? Okay. Well, thank you. You guys are staying tight. We appreciate it. Any members of the public wish to testify on this bill? Okay. I'm going to assume that Mr. Krieger is on for the Business Council bill. Okay. We'll go ahead and close public testimony. What's the committee's pleasure? Moved by Western, seconded by Air. Okay. Any discussion on the bill, committee? Representative Heiner?
Thank you, Mr. Chairman. I'm a little concerned as well with this open structure to the fees. As a legislature, we're actually delegating our authority to the commissioner with an open end. We're trying to think about today's situation, but also what's going to happen in the future. And by not having a window where this fee can be boundaries within this window, which open-ended at this time, I'm a little bit uncomfortable with that. And I just think this is a little premature without some more structure on that fees.
So I'll comment on that. And it's the reason why I brought House Bill 69, because we had several different new banking laws or things that were reviewed by the commission that didn't clearly allow for the rulemaking authority. Well, they were still doing rulemaking in there and setting their fees. And so a lawful constitutional delegation of legislative authority is to allow and give an agency that rulemaking authority. And the fact is, when they do that, then you have all of the stakeholders, the people that are interested in it, engaged in that rulemaking. And so if we were to do that as a legislature and sit here, our committee meetings would be 10 hours long as we tried to set out and we tried to decide what those fees were. So it's been working. If you recall, House Bill 69 allows the commission for the first time the ability to reduce fees or give fee holidays. And they are clearly in that restricted to just proving the costs of what is for their oversight. And then also we added that they have to report back to the Minerals Committee. So I just to address those concerns. Yeah. So, okay, any further discussion? It's good discussion. Okay. All right, seeing none, sensing we're ready to vote, we'll go ahead. We'll take a roll call vote, Carol, on Senate File 40.
Representative Bear.
Aye.
Representative Burkhart.
Aye.
Vice Chair Duncan has submitted an absentee vote of aye. Representative Air.
Aye.
Representative Gray.
No.
Representative Heiner. Representative Sherwood.
Aye.
Representative Western. Chairman Greer.
Aye.
8 ayes, 1 no, do pass.
Thank you. All right, next bill for our consideration is Senate File 148. And its requirements relating to depositor amendments. A very simple bill. Representative Western, if you want to present that, I did call Senator Rothfuss, but I didn't catch him, so. Go ahead, Representative.
Thank you, Mr. Chairman. Members of the committee. So I think the older members will remember some of the discussions that we had around some of these speedy banks or these special depository institutions. Did a lot of work with them, set up a bunch of new framework. I think some of us can remember those discussions. For the new members, over the last several years, the legislature has worked on a lot of these digital assets, crypto banks, blockchain bills. And we've done a lot of work and made a lot of progress in some of this stuff. And so that's kind of the background on what this bill relates to is some of these crypto banks, if you will, or these, we call them speedy banks. And so this bill is really straightforward itself. And right now, it just basically says, you can kind of really see there on page 2, it just on line 6, it just removes in the United States. And so what that is, why we're doing this is because all banks, whether they're small community banks or certainly the big, large national banks, a lot of their customers are international, whether they're from Canada or Mexico or overseas. And so that's kind of what we're going for right here, is just to make sure some of these speedy banks also have the ability to interact with customers from overseas. And that's really the gist of the bill. So if you guys have any questions, I'd be more than happy to answer them. Thank you, Mr. Chairman.
I have questions. So, obtaining jurisdiction over depositor, and there are a lot of restrictions on speedy banks for good reason. And again, anti-money laundering and the, know your customer rules, all of those things are are U.S. federal law and have been incorporated into this. And so if we allow the depositors to be outside the jurisdiction of the United States, what door are we opening up? How are we in Wyoming going to be able to regulate that and have some hope of being able to rein in bad actors? Go ahead.
Mr. Chairman, these speedy banks are subject to all the same, what we call KYC AML, anti-money laundering, know your customer regulations that we have both on the books at the state level and of course at the federal level as well, with FinCEN and some of the other regulatory agencies. So these banks still have to go through the same protocol and follow the same steps that they would have to do for any customer. And certainly, obviously, there's plenty of very legitimate customers that happen to be international. But there is, of course, the possibility for some of them are less than savory actors. And so in dealing with and weeding out the ones that we don't want to associate with, these speedy banks will have to go through the exact same protocols and have both at the state and federal level for some of these KYC AML measures that are both state regulated and as well at the federal level as well, both with FinCEN, the U.S. Treasury, and others. Thank you, Mr. Chairman.
Go ahead, Representative Burkhart.
Mr. Chairman, I think this is kind of a follow-up to the question you asked. That, excuse me, the speedy bank, my recollection is that statute says they can't be involved in an illegal activity. If we strike these 4 words and a company has a bank account, legitimate account in a country that maybe doesn't have as good banking laws, and that money comes from an illegitimate activity, but they're in good standing with the bank, how do we stop the fact that now we have maybe drug money, smuggled money, any number of things deposited in a speedy bank here? If they're legitimate in their own country, how would we ensure that we don't have them depositing money in a speedy bank in Wyoming that comes from, say, gun dealings in countries unfriendly to the United States?
Wind up, Senator Rothfuss. No, you're fine. Senator Rothfuss, we're just in the middle of quizzing Representative Western as to what doors are we opening up to illicit activities with this, Senator? And so go ahead with your comments, I'm sure.
Thank you, Mr. Chairman. Mr. Chairman, this is the equivalent of what's already done with state chartered banks. So there's nothing new here for a speedy bank. A speedy bank is a state chartered bank. And when there are international activities, Know Your Customer, Anti-Money Laundering Act, or anti-money laundering aspects of the Bank Secrecy Act apply. And they require heightened scrutiny. And again, regardless of whether it's a speedy bank, nationally chartered bank, state chartered bank, if you have engagements with foreign depositors, your KYC AML obligations are enhanced. To the extent that our speedy banks are regulated in the same way that our state chartered banks are regulated, the Division of Banking is obligated to ensure that the KYC AML obligations are met. So there are bad actors domestically, there are bad actors internationally, whether it's a speedy bank, which this specifically applies to, or a state chartered bank, obligations are in place based on the federal laws that provide that due diligence that's necessary. It's my understanding, and you probably haven't had testimony from the Division of Banking yet, but there really wasn't an initial intent to have this in there. It was effectively a drafting oversight of why did we put that in there, and nobody could really come up with a good reason, because again, it's KYC AML obligations that are to oversee and govern this, not having a statutory prohibition. And in fact, when you're dealing with a lot of the entities that the speedy banks are looking to deal with, international funds, hedge funds, other entities where you want to be able to have these larger interactions where you're dealing with digital asset custodianship and we're providing that unique opportunity, a lot of these other entities are chartered or domiciled in other countries. Even if they operate in the United States, they might be domiciled in the Cayman Islands, or they might be domiciled in the United Arab Emirates or another country. This language appears to exclude the ability to engage with those companies. And we've actually set up memoranda of understanding with a couple of other countries to specifically start engaging in this way, ironically, because we want to expand the opportunities for our speedy banks as they are the first of their kind in the world. This is a significant detriment. This was a request by the two speedy banks that we already have. We know that the future speedy banks that we have, we've got a round 3 in queue, need this type of exception removed. And I'll just close, Mr. Chairman, before answering any questions by saying the due diligence that's in place is sufficient and equal to the due diligence that would be in place for any other money transmitting or banking institution in the country.
So Senator Rothfuss, you wouldn't be offended if we amended this and said, be in good standing with the jurisdiction in which it is incorporated or organized, and that it was authorized to do business in the United States. And I asked that question because being authorized to do business means they've taken some action to submit to the jurisdiction of the United States of America.
Mr. Chairman, I would double check with the Division of Banking to see if I'm missing anything. I don't have any heartburn over that because I would expect that that would basically mean that you've been validated through KYC AML. I can't imagine you haven't if you haven't met the words that you just said. But I'd ask that you hold off and make sure that I'm not missing something with the Division of Banking there.
It'd probably be one of 10,000 factors that help me sleep better at night. If I
Well,
could
and that's
eliminate
what I
that.
aim to do.
Okay. All right. Any further questions for Senator Rothfuss or Representative Western? Okay. Thank you. Glad you got down here, Senator. Thank you. Does the Commission of Banking wish to speak to this? Or the Banking Commission? I guess that's the proper title.
Thank you, Mr. Chairman. Yeah, I'll just keep brief. I think the Representative and Senator hit all high points to your question. Yeah, that amendment would be fine. I'm not sure how it's worded in federal statute, but they are authorized, right? Any bank is authorized to open it. And of course, part of their enhanced customer due diligence for non-US businesses would be to ensure that they are in good standing of where they're located, as well as authorized to do business in the US. If they weren't, then there'd be problems with the account opening to begin with. I don't think it hurts to have it in statute to make it clear, make sure the intent, but otherwise, and to the senator's point, yeah, we do have we're starting to engage. We have 2 information sharing agreements in place, one with the Bermuda Monetary Authority and one with the Abu Dhabi Global Markets. So the financial regulator in Abu Dhabi that do a lot of digital asset activity, a lot of fintech work. And so we're putting those in place with jurisdictions that we know some of our chartered entities will be operating or are licensed to ensure that we have a free flow of information between regulators on either the entities themselves or potential affiliates that could impact either charter. And so we're working on that, something I wasn't sure I'd ever do in my career, but it's pretty interesting to try to engage with somebody in 11 time zones away. But nevertheless, that's part of our supervisory process as well.
Questions, Commissioner Faulkner? Okay, seeing none. Anyone else? Mr. Meyer, you wish to testify or you're good?
Members of the committee, Scott Meyer, on behalf of both the Wyoming Banking Association, is also on behalf of Scott W. Meyer, PC, an attorney that practices law here in Lander. I routinely see, as an attorney, clients that want me to form or to help them acquire bank accounts, clients from England, Australia, Belgium. And it's quite a process to get it done. And you have to come over here, open up the account, show everything that you have to do. This is no different for these particular banks. They do have a lot of regulations to go through, as Commissioner Faulkner had said. You do have to make sure you have your entities in good standing. They may want to form even Wyoming entities to get that done. But from a practical standpoint, this is nothing different than what any other bank is having to do, and we stand in support of the bill.
Okay, thank you. Any questions for Mr. Meyer? Okay. All right, anyone else wishes to testify on this Senate file? Senate file 148, seeing no one, we'll go ahead and close testimony. What's the committee's pleasure? Moved by Heiner, seconded by Ayer. Any discussion on the bill? I think I'll hold off on an amendment and I would bring it as a committee of the whole or something and flesh that out a little bit, but unless the committee decides otherwise.
So, Mr. Chairman, your amendment answered some of my questions and concerns with this. But if you'll bring it as a second reading amendment or committee of the whole amendment after you work it, I'm good with that.
I think I'll just discuss a little bit further before I do it, would be my thought.
Okay, thank you.
Okay, any further discussion, committee? Seeing none? Question being called. Carol, roll call vote on Senate file 148.
Representative Bear,
Aye.
Representative Burkhart,
Aye.
Vice Chair Duncan,
Oh, she's excused.
Representative Ayer,
Aye.
Representative Gray.
No.
Representative Heiner. Representative Sherwood.
Aye.
Representative Western.
Aye.
Chairman Greer.
Aye.
7 ayes, 1 no, and 1 excused. It would be a due pass.
Yep. Senator, or excuse me, Representative Western, I assume you're floor managing. Okay. All right. Look that up. Yep. Yep. Thanks, Senator. Okay. Next item for our consideration is Senate file 116, and then Senator Ellis, please come forward.
Good morning, Mr. Chairman and members of the House Minerals Committee. My name is Affie Ellis. I represent Senate District 8 here in Cheyenne. This bill is very small and straightforward, so you can debate it as much as you'd like, but hopefully, I'm not a gambling person, but my over-under on the House is 30 minutes on the floor for you if this advances. As you know, the Wyoming Business Council is comprised of 15 members. They serve staggered terms of 3 years each. There are 3 classes. Each class has 5 members per class. And the governor's office reached out to me before the session and asked if I would be willing to bring a bill to reduce that number from 15 down to 13. There's no anecdotal, or there's no report that I can offer you that talks about the right size of a board. But as someone who's served on different kinds of boards over the course of my career, I can tell you, I do think 15 is a little too high. So I thought moving the number down to 13 was a positive step forward. And so that's what this bill would do. It wouldn't affect any of the current appointments. It would take effect going into next year. And my understanding from the governor's office is that there are members who are termed out, so they no longer be eligible to serve. So this would be a very judicious way of removing two of those positions without upsetting our private citizens that are nominated and selected to serve on these boards. And then you'll see on the fiscal note, there is a modest savings. That was another reason I decided to bring this to your attention. And so, Mr. Chairman, I'm happy to answer any questions. I'm sure that, we could have a big discussion of, well, why not 8? Why not 9? Why not 11? I think that those are all fair questions. But at this point in time, this has got a very narrow focus. And certainly if the committee wanted to have those conversations going forward into the future, that might be appropriate. But I do think this is a good first step. Happy to answer any questions.
Committee, any questions for Senator Ellis? I do. I was asked to consider this as well, and I was going to address those issues as we looked at the Business Council in the interim. And I don't have a problem with the reduction. I'm just, you may not know the answers to these questions, but why was it 15? And as you aptly said, why not 11? Why not? That's what is the right size of a board. It's difficult to determine. And any insight you have on why it was 15 would be welcome.
Well, Mr. Chairman, I can tell you on the Senate side that one discussion point that we have often is it is really difficult to get people to serve on our boards and commissions, all of them. And so there are certainly boards and commissions that are higher profile, more desired, more sought. And so on the Senate side, when we review these confirmations, that is a factor that we consider is, we want to encourage the public to apply for those positions. And so when I looked at this bill and the narrow focus it had, I certainly don't want there to be any belief or misconception that somehow we're unhappy with particular members, that we're trying to kick certain members off, that there's discontent or things like that. And so the larger the number, I thought just probably needed a lot more study of, the next class that would be up, how many of those members would be termed out, those kind of things that I just wasn't prepared to evaluate at this point in time. So that's why it is narrow. It is 2 from this class. And those members would be termed out. And so those were the facts that I know that I've been given. And, certainly if you want to have those conversations in the future, in future years, should it be, should we make another jump down to 11? I think that those are better warranted in the future.
Okay. Committee, any questions? Okay. If you'll hang tight though, Senator, in case we do, we'll go ahead and hear from the governor's office.
Thank you, Mr. Chair. Mr. Chairman, members of the committee, Rob Krieger, Governor's Office. Just to hit on your question a little bit, trying to find the right size of this board. The 2 members that were up, that did work timing wise, but there's also 4 subcommittees of the board. And so when talking with the chairman and the past chairman of the board, with this reduction, each subcommittee would have at least 3 members. And while these are private sector business owners, we didn't want to put these subcommittees down to maybe 2 people per committee, because that could be a lot of work they're going to have to do. So, Mr. Chairman, to your point, I think trying to see how this works as we go through the next year and the year after that, then maybe reevaluating if further cuts are needed or whatnot would work well. But just want to say that we're in favor and thank Senator Ellis for bringing this bill forward, and I'll stand for any questions.
Okay. Committee, any questions for Mr. Krieger? Yep, seeing none. Anyone else wishes to testify on this bill? Cindy, you good? Okay, all right. Anyone else? All right, close public testimony. What's the committee's pleasure? Moved by Burkhart, second by Western. Discussion? Okay, did you have a question? Representative Gray?
No.
Oh, you had that inquisitive look.
No,
All right, okay, question being called, roll call vote on Senate File 116.
Representative Bear,
Aye.
Representative Burkhart,
Aye.
Vice Chair Duncan,
Excused.
Representative Air.
With respect to Representative Duncan, Carol, I'm going to leave that open, give her the same courtesy as we did Representative Bear to have a vote.
All right, Chairman.
Yeah.
Representative Air. Representative Gray.
Aye.
Representative Heiner. Representative Sherwood.
Aye.
Representative Western. Chairman Greer.
Aye.
8 ayes, 1 excused, do pass.
Why don't we go ahead and stand at ease for 5 minutes? Representative Bear, if you'll get ready, I'll go get Senator Cooper. Him and I are gonna maybe switch rooms, actually. And Representative, we're done, Senator Ellis, thank you. Representative Burkhart may have to chair the committee. So let's go ahead and let's just take the stand at ease for 5 minutes here. So Carol, with respect to Representative Duncan, we'll leave, her vote isn't going to change the vote on those bills, but we'll leave them open just so she's on the record. It's fine. Yeah, until adjournment. Yeah. Okay. Okay, looks like I'll be up in Senate Judiciary in about 20 minutes, so I'll just get us started. Okay. Was that 5 minutes?
Whatever.
Very good. Okay, so the next item for our consideration is Senate Joint Resolution 03. So we have Senator Cooper and then our own Representative Bear. So however you gentlemen want to present this, go ahead.
Thank you, Mr. Chairman, and members of the committee. If you remember about the end of January, 1st February, I think it was February 5th, we had a meeting with the governor regarding the executive orders that had been issued by the President of the United States, and we had some real concerns with that. And the governor asked us for a joint resolution to address it and to send off to the Department of Interior and the President and our Washington delegation. So Representative Bear and I worked together to develop this joint resolution. We had it ready right away, but in the speediness of our operations here, a month and a half later, we're still trying to get it passed. So with that said, The resolution itself, I'll just read the first paragraph to you. It is a joint resolution requesting Congress and the federal government to reverse federal orders and actions that inhibit the safe development of oil and gas in Wyoming and that negatively and disproportionately impact Wyoming citizens and industries. Okay, then we go into the whereases and explain
So
what the
Senator
situation
Cooper,
is.
if you want to hit a couple highlights and then maybe we'll just have our committee ask questions.
Okay.
Yeah.
What it addresses is the fact that the state of Wyoming, the industry in the state of Wyoming pays millions of dollars in taxes. We are the safest, most environmentally responsible operations probably in the world, the most regulated oil and gas industry anywhere in the world because of the volume of our federal lands. It does discuss the federal lands that we have 42 million acres of mineral estates in Wyoming that are federal. These decisions that are made, these orders have affected our labor pool. We have 20,000 jobs out here that are being adversely affected. It affects the state's ability to recoup our minerals, and it affects the landowners' abilities to recoup their minerals. So overall, these actions have been very negative to the state and to our citizenry. One thing that gets overlooked a lot is our wildlife. Game and Fish works very closely with a lot of different operators, especially in the western part of the state with these migratory corridors, and try to work timing through the year so we could minimize the impact to wildlife. So what this is actually doing then, after we describe the issues, the president put out 2, I believe, or 3 executive orders plus a secretarial order. We're asking him to rescind those. We're sending a letter to the president and to the Secretary of Interior and to our congressional delegation, asking them to address this in an expedient fashion and to further what's the right word? Yeah, we're going to ask them to rescind them and also to further investigate possible legislation to move things forward.
So and we'll take committee questions here in just a moment. On page 3, lines 18 through 23, to me are very significant and a point that's often overlooked. And you touched on it. Do you or Representative Bear want to comment further on that? And it deals with us being a heavily regulated state, and we do it better than anywhere else in the world. And this actually could lead to an increase in what they're trying to prevent.
Thank you, Mr. Chairman. Yes, that's exactly the point that we're trying to make here, is that the very thing that these presidential orders has done is created an opportunity for more environmental impact throughout the world. And environmental impacts are not regional, they are worldwide. And so that's the point of this particular resolution, is to bring that to the attention of the administration and ask them to think that through a little better before they impact Wyoming in such a negative manner.
Sure. Okay. Committee, any questions for these 2 gentlemen? Representative Heiner.
Thank you, Mr. Chairman. On page 4, we mentioned that up to 20,000 citizens may be directly or indirectly be affected by this change. In Wyoming, that's a significant percentage of our workers. Almost 10%. But in a large state or other areas of the United States, that may be minuscule. 20,000 workers, that's acceptable losses in other states. Would it be advantageous to us to represent what percentage of our employment sector that would actually impact here in Wyoming?
Senator Cooper, you want that one? Go ahead.
Thank you, Mr. Chair. Representative Heiner, I think maybe that's prudent to represent that as a percentage factor. The number with percentages or as a percentage factor, either way, I think would be prudent and probably effective. This was an amendment that was added afterwards, and I think we could amend that amendment.
We're fortunate because Representative Heiner knows all those figures right off the top of his head. Okay, good. Any further questions, committee? All right, we're moving. Oh, go ahead, Representative Bear.
Thank you, Mr. Chairman. I think you just mentioned this, but is that paragraph on page 4, line 10, is that the difference between the initial resolution and the engrossed copy? Was that an added as an amendment on the Senate side?
Mr. Chairman. Yes, Representative, it was added as an amendment on the Senate side.
Yep. Further questions, committee? Yeah, Representative Sherwood.
Thank you, Mr. Chairman. On page 2, the paragraph that is on lines 5 through 9, did you give any consideration of providing examples of the technologies that we are working on to promote responsible development? Things like carbon capture. Is it worth listing out those potential technologies?
Go ahead, Representative Bear.
Thank you, Mr. Chairman. Thank you, Representative Sherwood. Actually, in a resolution like this, we were trying to keep it simple and straightforward. We believe that the federal government does and is aware of those particular technologies. And so we just try to blanket statement that rather than get into the details and make it cumbersome getting through this resolution.
I'll comment too. It's a good thought process, but other than maybe the actions by the EPA, that when you carry into that, most of these were directed right at oil and gas, especially the secretarial order and then the leasing order. Now the overall component was all okay. I've got to go, so we've got. We'll be down. I did leave an aye vote for the record. Vice Chair Burkhart, do you mind? Thank you. I'll come back get my phone.
That ensures you'll be back. Follow up, Representative. Other questions? Okay, thank you. Just hang with us. Anyone here in the room wish to testify on the joint resolution? So Senator, you have to get back to committee, I think. Okay, thank you. Mr. Moline, please.
Brett Moline, Wyoming Farm Bureau Federation, sitting strongly in support of this resolution. I think I don't know if it needs to be in the resolution, but one of the large impacts of this is because of our intermingling of private and federal lands. What I'm hearing from some of my members, especially on the east side of the state, that if they have their minerals leased now, unless something changes with the federal, they might have it leased now, but if nothing changes, those leases might not be renewed. And if they're not leased, they're having a hard time finding somebody to give them what should be an appropriate value. So sitting in support of this resolution for the impact, for several impacts, the states, the counties, everything. With that, Mr. Chairman, I'll try to shut up and take any questions.
Any questions for Mr. Moline? Questions?
Thank you.
Mr. Moline, I do have one.
Yes.
Excuse me. Excuse me. You mentioned your members in the eastern part of the state. So are they sitting on private surface federal mineral? Or just a little bit of explanation, please.
Mr. Chairman, committee, it runs the whole gamut. It might be private surface, private subsurface.
Okay.
It can be private surface, federal subsurface, but it's, the instances where I'm most concerned about is where the mineral estate is privately owned and not being able to get an economic return on that because of what the federal government does. And other people can probably answer this a lot better, but if there's any chance that they're going to run into any federal minerals, will they develop the private minerals?
All right, thank you. Other questions for Mr. Moline? Thank you.
Thank you, Mr. Chairman, committee.
Mr. Obermuller.
Good morning, Mr. Chairman. Pete Obermuller with Petroleum Association of Wyoming. Until Vice Chairman Duncan came back, this was reminding me of the congressional committees in DC where we talked to one or two members. Nice to have you guys here. Thank you for doing this resolution. I really appreciate it. I'm here to give you any updates that you might want about where we are at the status of the leasing ban. Offer just a couple of thoughts. Number one, we, Petroleum Association last week joined with our regional partners, the Western Energy Alliance, in litigation against the Biden administration regarding this. The reason for that and applies to this bill, and the reason for it, Mr. Chairman, is that last week should have been the first quarter lease sale in Wyoming, and that lease sale was canceled pursuant to the Biden executive orders. Over the last 6 years, Mr. Chairman and committee, on average, Wyoming could have expected about $10 million from last week's lease sale. And the way that federal mineral royalties and lease sale royalties work in Wyoming, based on the formula that you all have set in the legislature, is approximately 4 million of that would have gone to K through 12 schools, and approximately 3 million or so would have gone to your general fund, and it breaks down from there in terms of counties, public infrastructure, and all of that. So, Mr. Chairman, the Mineral Leasing Act requires the federal government to do a quarterly lease sale. So we joined the lawsuit because having failed to do that last week, we believe that they have violated the law. So, Mr. Chairman, this resolution, I understand the general frustration from legislators. I remember your old colleague, Representative Tim Stubson, used to be irritated that he thought they could do is write terse letters, which is essentially what this is. But it is in fact helpful to make a public statement about these. Mr. Chairman, I'd be happy to answer any other questions about the status, lease status, permit status, or any of that sort of thing going on in Wyoming right now. But I don't want to take your time unnecessarily. So thank you for doing this, Mr. Chairman.
Any questions for Mr. Obermuller? Any questions? Mr. Obermuller, if you could give us like a 30,000 foot view of what the current status of the orders and that look like.
Yeah, Mr. Chairman. So there were two orders, one with very immediate impact and one that is a little bit more of a slow burn. The immediate impact order was the ban on permits. And this committee probably understands, but just in case, there's lots of steps before you get to the point of where you actually drill a well. The first step, of course, is leasing. And that does not allow you to actually go and drill the well. That just that sets up the space essentially. And then you have to get a permit after that. So the Biden administration had two bans going, one on the lease, the first step, and one on permitting, the second step. The permitting pause was for 60 days. And what that really was it took away the authority of local BLM officials to make any of those decisions. And consolidated it in DC. That I think turned out not very well for them. It was more difficult for them than they expected to try to consolidate that decision making. So the message from DC was constantly, well, day-to-day operations are ongoing. And it became pretty clear even to them very quickly that that wasn't true. The Wyoming BLM offices did not feel like they had the authority to make really just very basic day-to-day decisions. And so projects were halted because of that. That 60-day order has lapsed and authority has returned to the BLM, local BLM, thankfully. The Biden administration heard from lots of us, from Governor Gordon, from you all, from Democrat governors like Lujan Grisham in New Mexico and John Bell Edwards in Louisiana. And cooler heads prevailed there, and that has lapsed, thankfully. We'll see still how that sort of rolls out over time. The leasing permit, yeah, go ahead.
If I could interrupt then. So we're back to the normal process of handling sundries.
Mr. Chairman, that's correct.
Okay,
Yeah.
thank you. Representative Duncan?
Thank you, Mr. Chairman. Mr. Obermueller, I came late to the party. Are you in favor of this resolution or not?
Thank you, Mr. Chairman. Yes, we're in favor. Yeah. And just to finish the thought regarding the second part, the slow burn ban is the leasing ban. And that's what, the pause last week, that's what I was talking about there. The big question there has been, well, is this really an impact? Hasn't there been stockpiling, all that kind of stuff? That's been the general minimization narrative that has come from some. The truth is that it is a slow burn in the sense that the largest of the companies that have the capital to nominate and purchase rights to leases, large lease tracts, have been able to do that to a certain extent. I think I showed this committee a map of that. The largest companies among us would be able to wait it out a little bit more. Smaller companies have to lease more at the point they need the lease. So as this continues to be delayed quarter after quarter after quarter, the smaller companies, the mid-sized companies in Wyoming are the ones initially impacted. And then after that, it goes to the larger companies. So interestingly, it favors the larger companies, the particular leasing ban. The last thought, Mr. Chairman, and I'll leave you to it, is I think it was alluded to already. Even the most conservative, pessimistic projections of demand for oil and gas continue at a present pace and indeed increase the demand for oil and gas globally and domestically, at least for a decade. The most pessimistic projections do that. None of the Biden orders or any of that does anything about demand. All it does is shut off supply from one particular area, federal lands. And the result of that, of course, demand will need to be met. It will just be met somewhere else, private land states or overseas. So to the extent that carbon emissions are an issue that you care about, they do nothing. It's symbolism over substance. We can talk about carbon emissions all day if you would like, but simply sacrificing federal land states is not the solution. Thank you, Mr. Chairman. I've gone on too long.
Thank you, Mr. Obermueller. Carla, is there anyone in the waiting room?
Excuse me, Mr. Chairman. No, there is not.
Okay. Anyone else wish to speak on the bill? With that, I'll close public testimony. Okay. Representative Bear, you can come back up here now. Committee? Moved by Duncan, seconded by Air. Discussion? Representative Heiner.
Thank you, Mr. Chairman. I would like to propose an amendment on page 4. And great minds here in this committee may help me with the wording of that amendment, but I just looked it up and there are approximately 280,000 employees in the state of Wyoming. So this 20,000 citizens that would be directly or indirectly affected would represent over 7% of our workforce. So what I would propose is a little statement that says representing after 20,000 Wyoming citizens who directly or indirectly work in the oil and gas and related industries, on line 13, maybe adding representing over 7% of total employment in the state of Wyoming. And that may not be the best place to locate that amendment, but that's why over 7% of total employment in the state of Wyoming. That's good. What it does is just helps those in Washington realize this is significant impact for us.
So Carol, that amendment was made by Heiner, seconded by Air. A discussion on the amendment? Air. So what I have is on line 13 after and related industries representing over 7% of the total employment in Wyoming. Am I correct, Representative Heiner? Okay, so that's the amendment. Discussion on the amendment? Question being called. All in favor, say aye.
Aye.
Opposed, no. That amendment's adopted. Okay, question being called. Carol, please take the roll.
Representative Bear,
Aye.
Representative Burkhart,
Aye.
Vice Chair Duncan, Representative Air,
Aye.
Representative Gray, Representative Heiner, Representative Sherwood.
Aye.
Representative Western. Chairman Greer has submitted an absentee vote of aye.
Okay.
That would be 9 ayes, do pass with amendment.
Thank you. So Representative Bear, I assume you'll floor manage this. Thank you. Hey, anything else for the committee? We did everything else, Vice Chair.
And everybody knows who's carrying what on it?
Yes. Representative Bear.
Did give her an opportunity.
Yes, she did. Okay, with that, we're adjourned.
Thank you, Mr. Chairman.